Most business disputes that people have, even ones that are brought to court, end up settling. In the United States, for example, less than 1% of court cases that are filed end up going to trial, and that's because the parties themselves reach a resolution. One way that parties can reach a resolution is simply to try to settle themselves. But another way is to approach a mediation process, to use a trained professional whose job is to serve both sides' interests. Just as it's true that people need to prepare and learn how to be good advocates in an adversarial setting, there are specific skills that you can learn to be the best representative possible when you're working with a client in a mediation setting. Being an advocate for a client in a mediation process is a learned skill. And what we're going to do in this film is help you to think how best can you use mediators to achieve the most favorable outcome you can for your client. The lawyer's job is to recognize the advantages of this particular process and to use those advantages. The whole point of being a lawyer, of advocating for a client, of working on the side of a client, is to help them achieve the resolution they want, to help them solve a particular problem in front of them. In this film, we're going to review some of the things that will help, some of the attitudes and some of the specific skills that lawyers already possess that they can bring into use in this process. I should just add a note that I'm an American law professor teaching in American law schools and work and practice in the United States. The goals of mediation tend to be the same in every jurisdiction, but the specifics of what the legal process outside of mediation might look like, of exactly what the rules are that might or might not govern the mediation, those probably vary from place to place. The styles of conversation, the way that parties talk to each other, those might be different in different places and in different cultural contexts. So please take the information from this and adapt it to whatever your setting is. The first part of any mediation process is hiring a mediator. In order to do that, you need to find somebody who is going to be available in the times that you need. It's going to have the style and approach that works for you and works for all of the other parties that are going to be involved in the mediation. Has fees that seem reasonable and are acceptable to the other side. So here's an example of how you might have an opening conversation with somebody that you're thinking of using and working with as a mediator.
Good morning, Mr. Mediator. My name is Frank McCall. I'm with the firm of Hungadunga & McCall. You may have heard of us. Right. I'm calling you about a possible mediation. My firm represents Hendrick Lumber, which is a local company, and this is a claim for gender and race discrimination. Is it correct that you've got experience in employment mediation? We're thinking of doing this at the second half of next month. Is that something you can be available for? Okay, all right. Do you have any questions for me? Okay, thanks very much. Bye-bye.
There are definitely things that you should avoid in talking to a mediator. Here's a couple of things not to do.
So tell me something about your experience. Have you done many of these? And what about recently? Well, can you give me the names of the parties and the counsel in the recent one? So tell me how it went. I mean, how did you feel? I mean, did you think that the employer had a better case? And if so, were you able to help them out and get a better settlement?
Asking a mediator about prior mediations is likely to not get very clear answers because the mediator cannot reveal any information, including the existence of a mediation, without explicit permission from one of those parties.
And we want a mediator who's going to help us get the best result. I assume you know what I'm saying. Sure. I mean, the idea is to save money, right, to get this done quickly. And now what about rates? How do you charge? Oh, Well, what about alternative fee arrangements, like a percentage of the settlement? Would that work for you?
One of the things that we would never want is for anybody involved in a mediation to feel like the mediator had a stake in the outcome. So if there's any way in which the mediator's compensation is in any way connected to what happens, the parties themselves might not feel like the process was being conducted solely for their interests.
Well, we might use you, but if it goes well for us, we have other cases in this area, and we would want to use you again if you are helpful to our client this time. I'm sure you understand.
Part of what makes settlement conversations work is when the parties are able to feel confident and comfortable and trusting in the process. In most mediation processes, the parties will be asked to prepare some kind of written submission in advance. This is a place where you, as their attorney, can lay out the facts and the law that pertain to the case. But there's more that the mediator may ask in advance. There's more that you can offer so that you can take the best advantage possible of this process. We can talk about what settlement objectives people have tried in the past, what, if any, barriers have existed that are getting in the way of the parties themselves being able to resolve this, and what is the major concerns that parties might have. What does your client want to achieve? What barriers have you seen that are getting in the way of achieving that? Is there any specific assistance you want from the mediator that would help you work more effectively on your client's behalf? If there are things about your side or your client that you cannot reveal to the other side but that are getting in the way, it's actually helpful if the mediator knows about that. Every settlement discussion, every problem resolution process always is done in the shadow of what happens if this doesn't work. So in your preparation, thinking through on your own as a lawyer or with your client, what happens if we're not successful in achieving the kind of resolution that this process is hoping for? If we're not able to achieve a settled resolution, there's going to be continued expense, there's going to be continued hassle, there's going to be continued time commitment, there's going to be continued worry about risk. And those things need to be on the table. Some of the preparation work that is necessary for this process is all of the preparation work that you would do for an adversarial process. You need to know your client's facts and law in and out. There's more. You also need to know, what does your client need? What is your client trying to achieve? What will make a settlement happen? If you only convey to the mediator the facts and the law, you're not using this process and this service as effectively as you can. There may be some stuff that feels not fully appropriate or not fully safe to put down in written submissions. But there may be reasons why a more informal conversation or something that is not reduced to writing feels more appropriate. There's nothing inappropriate about speaking privately or individually with a mediator. If there's things that you want to tell a mediator privately, call them, talk to them, tell them what they need to know. The more information you can give the mediator about what you need and about what you think the other side might need in order to move beyond just saying, yes, we have a dispute, but instead move towards saying, yes, we can resolve the dispute. So now you're in the room ready for the mediation to begin. Chances are the mediator will ask each party to present some kind of opening. What the goal is to begin to get things on the table to reach resolution. Now, the law and the facts of your case obviously affect those things. But it's also helpful to understand that those are only parts of your objective, because those are the background. That is the shadow of what happens if the mediation process of trying to reach a resolution is not successful. It's never a bad idea to remind us of those things, but that's not the focus. The point of the process is also to begin to understand, what are you seeking? What positions do you have? What do you want from the other side? What do you understand or not understand about what they're bringing to settlement? The more you can reassure that yourself and the other side that you are there to try to achieve a deal, and that you are open to hearing what they have to say, and that you hope that they will also be similarly open to hearing what you have to say. So when people are making their opening, who are they making it for? Really, it's for the other side. It's to hear the positions and the concerns and the care that will help the other side to understand what they need to bring, what they need to resolve for your client in order for your client to be able to accept a settlement. the more the parties hear from each other, sometimes it can surface misunderstandings or even accurate understandings that were the source of conflict. It is, in fact, a really important messaging for both the client and the lawyer. It is a way to hear and understand what the other side is concerned about. It is hopefully a way to hear and understand things that may not have been even known or visible before we got into the room. And that's why the listening job is every bit as important as the speaking job, because it's only in understanding what's being said and possibly doing some of our best work, understanding what isn't quite being said and what further information we need to ask. Hopefully, that's what people are doing. It's hard, but it is some of the most important work that we do. Everyone has seen lawyers in mediation who somehow think that their job in the mediation setting is exactly the same as their job in court. You can do that. You can proclaim loudly every legal claim that your client has.
I listened to counsel for claimant make his presentation, and I expected to disagree, but I was completely appalled. I mean, claimant knows that she was dismissed because she's a difficult human being. You know it. Everyone in the company knew it. She worked at the company for 5.5 years and she was a constant irritant, even when she was doing her job well. It's completely ridiculous that she and her lawyer, her so-called lawyer, would come here to shake my client down for money just because she can bring a claim in the United States courts. Well, she can try, but she's not going to succeed. As the lawyer for the claimant knows, I'm a trial lawyer. I try cases. I don't settle cases. And, you know, mediation is for people who don't try cases. But my client said he wanted to try to do something because he doesn't want his business to be diverted, and I understand that. But let me tell you, we're only here for the moment. I want to try this case. How much is my client willing to pay? Does the concept zero have some meaning to you? How about nil, nothing, nada, goose egg? Do you know who I am? You ask your lawyer who I am. How many cases has he tried against me and won? How many cases has he tried and won? How many cases have I won? Check it out. You won't want to go ahead with this. So see what you can get today and have done with this.
Forceful advocacy for what our clients care about is never a thing we abandon. And yet, in the settlement discussions, we are forcefully advocating for what our clients are there for, which is achieving a resolution that is exactly something that they can live with and that the other side can live with. Here's a summary of things you want to keep in mind when you're preparing your opening. Obviously, you're going to want to begin with a basic factual narrative of what has happened that has brought us to this point, and probably what legal claims you have. You also want to include an explanation of why you have reason to feel confident about your claims. You want to also, though, indicate your openness to achieving resolution in the mediation process itself. And finally, you want to include an expression of interest in learning from the other side what it is that they need, because no resolution is going to be achieved if both parties don't walk away with something that they can live with.
Good morning. We're here because claimant has brought a claim, or wants to bring a claim against my client for gender and race discrimination. And we're here to try to resolve this matter. Now, we're very happy that we heard claimant's version of events. This termination happened for a reason. And it wasn't because claimant was not a good producing employee. It was because of her personality. Claimant has been abrasive in her 5.5 years with my client, and this has caused many problems. Now, claimant does not have a contract, and so claimant has no right to be employed. And we made this decision somewhat reluctantly because of her long service with us, but necessarily because her relationship within the company was causing problems with people under her, people she worked with, and with management. Now, as she knows, the woman we hired to succeed her is a woman of Asian descent, which on its face suggests that the reasons for terminating claimant had nothing to do with gender or race. But we also think, independent of that, any witnesses who testify in this case would confirm that gender or race had nothing to do with her performance or her evaluation or her termination. Now, Hendricks Lumber would like to settle this case because we know it's time-consuming, it's expensive, it's diverting, and frankly, it's upsetting to be in litigation. So we're here in good faith to work with the mediator to see if we can come up with a resolution, which will require compromise by all sides. And if we succeed, each side is going to save a lot of attorney's fees, time, and the emotional cost of going through a situation like this. In addition, if we settle this problem without litigation, we're not going to have to take the risk of this private matter becoming public. And then everyone can go on, Hendricks with its business and claimant with her life and her career. So we thank you very much. We're going to try our best.
An advantage of having a mediator is that parties can share information somewhat differently. Mediators can be told information that you might not want to tell the other side, but that is going to affect how any kind of reasonable settlement can be structured.
Mr. Mediator, my client's a very proud man. He started this company. And the last thing he would want to tell anybody is that he's got problems. But the truth is, the company is not in the best cash position now. So its credit facilities are stretched. It doesn't have much cash on hand. There is no material payment, no payment that I think the claimant would accept to settle this case that could be paid in a lump sum. My client is simply not financially able to do that. So a settlement would have to be a structured settlement, X dollars over X months to satisfy the settlement obligation. So you can help us, Mr. Mediator, by making it known that the company is not a deep pocket here for the reasons I gave. We're not asking them to take our word for it. So, for example, if we proposed a structured settlement and they agreed to that subject to seeing the financials, we would then show the financials.
And you can tell the mediator what the mediator is allowed to share and not allowed to share with the other side. You can ask questions that will help the mediator understand what your client's concerns are and to work with the other side to get information that would at least satisfy a concern that you have.
You can help us out here. We had employees who left the company because of her, and employees who left the company who very well understood her behavior. We think they could be very valuable for us, but we didn't keep track of them. We're not that kind of company, so we don't know where they are, and we don't know what they would say. We can try to find them when the time comes, but we're also interested in knowing whether the claimant has been in touch with these people and whether, unlikely as it may seem, they might be witnesses for her. It would help us a lot if you could get some insight into any of that information. Because, depending upon what it is, it might affect what we're willing to propose. I recognize that they may not be willing to confide that to you, or if they did, that you couldn't confide it to us. But I think that simply by asking them that question, it might help them understand that, they don't have access to such people. On the other hand, if they do, and they're confident, maybe they would authorize you to tell us, because if they have that in hand, they might want to show that to us or indicate in some way to make us move.
Not every lawyer approaching mediation is as strategic as they could be in thinking through how will I gather information that I need in order to resolve the problem? How will I give information without disclosing things that would be unhelpful to disclose or impermissible because my client doesn't want it given? The more we think that through and use the mediator as a conduit to sort of shape what information is given and shape what information we receive, the more we have at our disposal to consider when we're trying to craft a resolution. The whole point is to have as many tools as possible available, and the more tools we have, the better resolution we craft, and the more opportunities and options your client will have available. Mediators are by definition neutral, but mediators are also people who are profoundly experienced in the skill of conflict resolution, which means managing the kinds of difficult emotions that can get in the way. And so if that's a concern, That's a thing to bring to the mediator's attention. Sometimes mediators who are not involved in the lawyer-client relationship simply get heard differently than the way that the lawyer would. If you have a client who needs to hear you advocate for that client's position, find a way to do so. But find a way to do so that doesn't stop or obstruct the goals of the mediation itself, which are to try to achieve resolution.
You know, I too have a lot of affection for my client, in part because I respect him so much. He built this company from nothing, and he's very proud, and he doesn't like to be falsely accused, which he feels has happened here. So I have a client here who pays my bills regularly, who understands the budget for this case through trial, and tells me he would rather pay all of these expenses and lose than pay this claimant any money in settlement. I have tried to explain to him that every litigation, including this one where I think he's got a good case, every litigation has risk. He refuses to see it. I think he understands what I'm saying, but I need help from another person, a trusted stranger, a mediator, to give support to me and outside of my relationship with him so he can hear it, not from his gladiator, but from someone who's experienced in settling these matters. And he needs to understand that losing the case is not just a question of upholding his moral principles, but that he may expose the business to real risk, which means exposing his family to real risk, because this is a family business, and it's all they have.
Every lawyer has worked with clients who are easy to work with or more challenging to work with. It is a profoundly intellectually rich but challenging relationship. One of the most important ways we advocate for our clients is helping them have a realistic sense of what to expect from a legal process that chances are they have less familiarity with than we do. So it's not an uncommon experience for lawyers to need to explain to clients that their expectations are unrealistic, or that they've failed to take into account what the other party's concerns are, or that they're not fully understanding what might happen if they don't achieve a resolution in a settlement. That's where you can use a mediator as well.
The reason we hired you is because you bring a fresh perspective, and I know he respects you, so he will listen to you. And sometimes we need to have things repeated to us, sometimes by other people, and I think you can fill that function. You may not succeed, but I think it's important for you to try.
We listen to different people differently. The mediator is someone who may be listened to differently even than you are, because your client should know that you, their advocate, are on their side, but they also hear things differently from someone else than they hear from you. Use that as an advantage in your own way of structuring your conversations both with your clients and with the mediator. Mediators are experts in trying to seek resolution. And one of the ways you can best use the mediation process is being aware that there is someone out there who may have specific expertise in problem resolution and has now developed at least some awareness and some expertise in your client's specific problem, who has ideas that you and the client haven't thought of and that the other side has not necessarily thought of. If you're stuck, if you're looking for other solutions, if you're looking at other alternatives, ask the mediator.
We may be in a difficult position, but it occurs to me that there may be something that she wants and needs that isn't money that might help get this done. I don't know what it is. My client would never offer an apology, but my client might be able to say something conciliatory. Also, it might be a conversation worth having, and for her lawyer, if he's thoughtful and introspective, to maybe talk to her, because we all know these cases are about emotion as well as money. And she was fired. Feels terrible. Maybe there's something we could do that isn't economic.
No one is bound to accept what the mediator suggests. The mediator's there to try to help people reach the resolution that they themselves are struggling with. Who among us has not had an opportunity to have a friend or a colleague suggest something that you hadn't thought of yourself? We know that that is valuable when friends, family, and colleagues do it. It can be equally valuable when a mediator does it. Use the strength of their experience. The mediator is likely to be heard by everyone in the room differently than the advocates or the parties. You can use that to your advantage. Sometimes there are things that might be said or asked for, offers that might be made, ideas that might be shared, thoughts that might be aired, that simply sound different coming from the mediator than they would coming from the party. If that's important, use the mediator for exactly that purpose. If there's something that the other side needs to hear or know, whether it's an offer, a proposal, a suggestion, a question, but that would come off better and read differently when it was heard from a neutral rather than when it was heard from a party or the party's advocate.
The problem is that as things stand now, they're near the end, and if they keep going up, they don't know where it's going to end. So they're afraid of overextending themselves for no purpose. But if you were to suggest a number that, even though much higher than what they think they can pay now, you could assure us would do it, or you think would do it, that might help me push my client along.
Ask the mediator to pose the question, state the information, make the offer, explain what needs explaining, because it's going to register differently when it comes from the mediator, and that is exactly what the mediator is trained to do and available to you for.
You know, Mr. Mediator, we know each other pretty well, and you know that lawyers game the mediators all the time. They're not honest with the mediators, and since we know each other, you will believe me when I say that my client has authorized me to offer $175, but not to do it directly. They will not offer $175 because that might not be the end. I'm telling you that they will pay $175, but I'm asking you if you can find a way to get this case to resolve at that number and no higher. And I'm suggesting the way to do it is to make it your proposal and not attributing it to us. Is that something you could do? So what I'm saying, Mr. Mediator, is to be very specific. It is not our bid. It's your proposal. To put it another way, the same words from me for my client will be understood differently than if those words are said by you. So if I say, my client is prepared to settle this case for $175,000 today, you can say exactly the same words, but no one will assume that you're negotiating. It's your evaluation at where the case can settle. It's not a position.
The mediator is listening to every side. The mediator therefore may have questions, comments, places to probe, suggestions, either privately or in public session, may have questions for you and your client that raise issues that either the mediator is seeing or that the other side has already raised. You can respond argumentatively.
We have them dead to rights. They're dead in the water. This case is a slam dunk. The law is totally in our favor. They can't possibly win on the law.
You can respond with only the claims that you would raise in court.
If we make a dispositive motion, it's going to cost them a lot of money, it's going to cost us a lot of money, and their case is going to be thrown out. So they might as well save all that and settle the case now.
That's not making great use of the mediator. And that's because if the mediator is pushing on any of these things, there are areas of tension that the mediator is seeing getting in the way of reaching a resolution. Answer the questions as best you can. Explain what your concerns are. If the mediator seems to misunderstand something, this is exactly an opportunity to correct it. You don't need to respond defensively. You don't need to respond argumentatively. You need to respond effectively. If the mediator is asking questions or pushing back or raising issues that you hadn't considered or encouraging you to consider other things than what you had put on the table, take that as coaching. The mediator is saying those things for a reason. Learn from that and use it in ways that guide the way that you present the information or that you frame or shape what you're going to say. The mediator may question the timeline. For example, does delay hurt you? Does it help you?
The longer it takes, the better.
The mediator may ask you questions about your client's concerns about expense and what exactly will make things worse or better over time.
We can wait her out. My client has the money to keep this case going until the end of time. She'll wear out. She'll run out of money, and we're happy to have her do it, so she should settle now.
The mediator may remind you that risk is inherent in any conflict that any parties experience.
We know what mediators say, and we know what is usually true, which is that litigation costs too much, it diverts the time of the client, it's emotionally draining, case should settle. But those things don't apply here. Our client believes he's right, he doesn't want to be held up.
The mediator may remind you that the objective in the mediation is a business resolution that works for every party, not the legal resolution that might take place if the mediation does not result in a settlement.
You know how to do your job, but I know how to do my job, and my client knows how to run his business. So all these things you say about cost and time and pressure and reputation, those are for other cases. Those are for other people. It doesn't apply to my client. It doesn't matter here. We don't need to hear from you on this. Don't waste your breath.
This is not the time or the place to argue for the purpose of persuading anyone. This is the time and the place to put out ideas and possible resolutions that will allow parties to reach solutions that everyone can live with, which is ultimately in their best interest. Lawyers are often competitive people. We care deeply about our cases and our clients. Sometimes that can get us a little too committed. Mediators can help us move beyond that. They can help us see ways to achieve a resolution, to solve a problem that we ourselves might not have come up with alone. Use them for that process, use them for their expertise and skills, rather than trying to persuade them, and you yourself will be the best possible advocate for your client in that setting. Let's suppose you've been successful in reaching some agreement with the other side.
Great, it's a deal. Send me the draft. We're out of here.
You're not done. No mediation is concluded until something is written down. Why? Because we want to have a commitment that is shown and available by both sides. Now, a lot of lawyers get nervous about that because we know how much time and attention goes into carefully crafting every word of an agreement. Doing so at the end of what may have been a long day of discussions and conversations can make lawyers nervous. It's still important. Advocates don't have to insist that every single possible issue that ever wants to be written down has to happen there in the meeting. Parties could reach a memorandum of rough understanding in which they write up in broad strokes what they want.
Okay, so we pay $175,000 in installments for 7 months. You withdraw the claim with prejudice, so you can't reassert it. And we both release each other from any other claims whatsoever. Everybody agrees to keep this settlement confidential. And everybody agrees that they will say nothing negative about the other side.
And then add these words at the bottom of the page.
Although the parties contemplate the exchange and execution of further documentation, they agree to be bound by these terms.
Expect that there will be some kind of written commitment of agreement if you've agreed, because that's what makes it something that we can move forward from rather than redo.
All right, now I'm signing, and my client's going to be signing, and we'll ask you and your client to do the same.
fundamental role of lawyers is to represent our clients. In order to represent our clients, we sometimes advocate for them, and many of us are fiercely good at putting out our clients' positions and explaining them and arguing in their favor. It's not uncommon, though, to find ourselves in settings in which it is better for our clients to resolve a problem rather than to continue to debate a problem. In that setting, the best way to represent your client, to put forward your client's interests, is to embrace the objectives, which are to try to understand what would be necessary, what would be helpful, and what would achieve the resolution of the problem that brought the client to the mediation in the first place. That doesn't mean we stop caring deeply for and advocating for our clients' interests and our clients' needs. In fact, quite the opposite. Mediation is about trying to achieve those things. But if we approach it exactly the same way we approach argument in other settings, we end up butting heads rather than trying to solve problems. It doesn't mean we lose or give up our obligation to represent their interests. Quite the opposite. It means we pursue their interests while recognizing that, at least in a mediation setting, their interests are on resolving conflict wherever possible.